Hi, my name's Anthony Alder, and I'm from Alder IP, and welcome to another episode in the IP series. Today we'll be talking about design protection and registering designs and processing designs in the international market, but also in the Australian market. The way designs work is particularly unusual. It doesn't work in the same way as what a trademark works or a patent works. The difference with a design is in Australia, when you file a design application, if it meets the formalities requirements, it'll be automatically granted without examination. The granting process usually takes about 2 to 3 months, and you usually get a certificate to say that you've got a granted, registered design, which is fantastic. The problem is when you go to enforce that, you have to have it examined, and it has to be substantively examined by the Trademarks and Designs Office. So when they do that, they're only really looking for one thing, and they're looking to see whether your design is novel. And that's what the main thing that the Australian Design Office looks for. With this novelty search, they tend to not cite a whole lot of formality objections. And typically at the Australian office, its regulations are very light on in relation to designs, much lighter than, say, most of the comparable overseas jurisdictions. Which brings me to the next problem, is the fact that quite often people will file a design in Australia and it won't be able to be used for an international application because their Australian application wasn't done up to international standards. Now, for international standards, a registered design must include black and white line drawings of the actual device, and it must show the device from all the perspective angles and all the side angles that we could possibly hope for. So you need at least 7 views of the item to be able to be useful in an overseas environment. Also, the other thing is that you must file the overseas applications within 6 months of filing the Australian application. And this is a rigid date that's not extendable. If you miss this date, you will not be able to file protection in overseas countries. So if you have an Australian design, you've got 6 months to make up your mind as to which countries you want to file into and which ones you want to get protection in. A lot of the countries have different rules regarding examination. USA, for example, does examine all designs that go through. And it's not uncommon that they will reject your Australian design just on a basis of shading and require you to put additional shading into the drawings, which is not uncommon. And it's also not uncommon to get the reverse objection when you go to China and the Chinese government asks you to take out all the shading. And these are some of the nuances that we have to overcome. Also, some of the other countries actually grant these applications without examination, and examples of these are UK and Europe, where they just automatically grant them. They actually have lower standards than Australia. For design protection, once it's actually granted, they last varying lengths of time depending on the countries. In Australia, design protection will last 10 years, in New Zealand it'll last 15 years, USA it'll last 20 years, and Europe it can last up to 25 years. It's fairly confusing as to how long each application will last. So it's important that you get a grasp of how long you're getting protection for each one of these jurisdictions and what's the requirements, because some of them are quite different to others. A US design application will cost you more through the prosecution phase, getting it granted. But once it's granted, there are no renewals on the US design and it will just keep sailing for 20 years. Where if you pick a European design, it goes through without examination, but you've got to pay a renewal fee, a fairly large renewal fee, every 5 years. And these are all things to take into consideration when you're going for a design. The main thing is with a design is that it's really just protecting the shape and the configuration of the item that you're trying to protect, and not so much the functionality. I hope this helps you understand some of the nuances behind design protection, both in Australia and overseas. And if you have any other queries about design protection, please feel free to contact myself, Anthony Alder, or the team at Alder IP, and we'd be happy to help you. Thanks very much.